on this, my lord. Please come to second status report and the conclusions. Based upon your lordships have, my lord, seen the entire, all the three reports. I am not troubling your lordships with this, my lord, but your lordships would, my lord, with respect, my lord, agree that it is a very scientific investigation, and based upon the interrogation of the accused and other, my lord, antecedent facts, these are the two conclusions which will assist your lordships so far as the present purpose is concerned, my lord. At page 13, second report, conclusion number 113.7. No evidence has come on record that the solved paper was circulated in any form randomly. Except the 4 locations mentioned above, there is no evidence of any other location so far. The total number of candidates who got benefited from the stolen paper are around 155, around 30 in Patna, and around 125 in Hazaribagh. This is for the purpose of, my lord, segregation, that whether segregation is possible or not, my lord. Your lordships may also, my lord, be assisted by para 11 of the report, my lord, which is at page, sorry, that may not be necessary, my lord. We have shown 2 figures, my lord. My lord, two pictures. Please, my lord, have a look at how the, you have shown that the position of the bag was different. No, my lord, I can show, my lord, it was not shown by my lord. Please come to page 11 of the second report. Page 11 of the second report. Well, just to show that this was done on 5th morning, apart from the CCTV footage we have, well, this is what the position of 2 trunks was in this particular institution. Image of the location of 2 trunks in the control room at OSS school at 7:53 a.m. on 5/5/24 when the front door was locked. This is image taken from the CCTV footage. Both are, my lord, connected to each other. Correct, my lords? Now, next page, my lords. Image of the 2 trunks at the control room of the OSS school at 1 p.m. on 5/5/24 when the officials went to open the 2 trunks before the examination. Both have changed their positions, my lord, and there is a tablecloth is also moved. My lord, this is to satisfy your lordships that this is the theft which happened between 8:02 to 9:23, because that is corroborated by the CCTV footage.
Yes.
Lord, just see, my lord, how your lordships have dealt with this, my lord. And I'll come to the last point. Lord, this judgment in case of Tanvi Sarwal, Lord, your lordships, my lord, latest judgment of my lord, the Chief Justice, my lord, is there, where your lordships have discussed all the judgments, but my lord, only few of the paragraphs of this judgment. Here, the investigating agency came to a conclusion that the paper was leaked and paper traveled through several states. Lord, if your lordships can take this, my lord, 2015, volume 6 SCC, page 573. I'll not read the entire report, my lord, which was placed before the court then, when this issue was decided. CBSE examinations, my lord, some 2 lakh odd students. Your lordships may kindly see page 587. Just giving my lord a flavor of what investigative report was before the court. Just below classitum D, after my lord the italics, the above mentioned 44 beneficiaries appeared in the examination at various centers spread across the country. Out of this, 15 candidates appeared at Siliguri, district Darjeeling, West Bengal, 11 in Rohtak, Haryana, 4 appeared at Ajmer, Rajasthan, 3 appeared at Delhi, 3 appeared at Jamshedpur, etc. Then para 6, that from the investigation conducted so far, it has been revealed beyond doubt that the network of this organized gang was spread across different parts of the country. Beneficiaries so and so were already arrested, so and so. Thereafter, again, the court says, then kindly see at page similar facts, where details are given that it was an all India scam as per the report of the investigation. Here, the report without any reservation say that so far we have found that these are the only beneficiaries. Of course, if some new name surfaces, his result would be subject to the outcome. But the question, which is for your lordship's consideration is that based upon a mere apprehension, which is not based upon any concrete evidence, would your lordships consider compelling or rather requiring 23 lakh odd students, painting them with the same brush as if all are guilty?
Yes.
When the investigation has categorically reported before your lordships that we believe that this is at these 4 places. And that analysis is corroborated by the IIT report. But I don't wish to take your lordships to the IIT report, my lord. Would your lordships like to be assisted with that?
Not necessary.
Not necessary, my lord. It is also corroborated.
We have seen the IIT report.
Yes. It says the same, that the pattern is same. It's not an all India phenomena where there is any sudden spurge. And more particularly, my lord, the thing which convinces us, my lord, is that their modus operandi is very clear: to select people, go to them personally.
Yes. Understand one thing. Is there any forensic evidence that the telegram paper was in the same form and pattern as the paper which was leaked out?
It must have been.
Just ask your.
You can answer that.
Any forensic comparison of the two papers were made or not?
Where the paper which was posted on Telegram on 7th or 4th, leave it right now.
Leave the date. Just the forensic.
Leave the date. Whether it was the same question paper which was used in this examination, that's the question, Manoj.
Not the same. Whether it was in the same pattern, that same font was used, same structure of the questions were there, or it was in a different format or different pattern. Questions may be the same.
I think, Manoj, from the he can answer, Manoj, directly, but my instructions were that while uploading it, the middle part.
This question is being put for only one reason.
Yes, Manoj.
If it's a leaked out paper which has been posted on the Telegram, then matter ends. If it's an information which is independent of the leaked out paper, then it's serious.
Correct, Manoj. What has happened is.
So therefore, is there any forensic comparison of the two or not?
Question paper comes to the candidate in a logical.
Candidate would be getting from the same press. So the fonts and the pattern would be identical. The question numbers may vary, the answers may vary.
Yes, sir.
But the font and structure would be the same.
It is the same.
So the question which was there in the public domain as a leaked out paper, whether it matches with the one which is there on the Telegram, that is the question.
The question paper is of the question paper of this examination in the same font, I think. There is no.
Is there a report and examination of that or not?
No.
Whether any effort was done to that extent?
Any forensic report is there? Any telegraph contains the same font, this, that, and others. Is there any forensic report on that? There is none. We must take it, Manoj. But otherwise, Manoj, what yesterday, Manoj, we will have to rule. Absolutely. But otherwise, Manoj, what I was told is that it is the same paper which was given by a student.
Because you see, the telegram, which is the photograph of that paper is there on in your report.
Yes, Manoj.
It doesn't matches with the one which is there in the case diary report. Not only in the font pattern, but also in the, as far as numbers are concerned.
Page 11. Page 11, Manoj. Your lordships are comparing it with
That booklet again, please.
which one?
Which we handed it over. The answer sheet, sorry, the question paper.
The question paper. Is it again back? For your lordship sees that. After examination was over, some student
He
gives
must be carrying the papers.
no, gives it to either uploads himself or gives it to someone, and with a view to hide his identity.
They must have masked the number. But whether the font pattern, the structure
Must
pattern,
be same. Must be
that has to be forensically examined.
yeah, yes, Manoj, that should have been done, and we will do that.
Students retain the question paper after the.
They always retain, but they are supposed to give the OMR sheet back and take the paper out. Otherwise, Manoj, it would be easy to trace the person, track the person. It may not match, Manoj, because of the jumbling. But it may not match because of the series being different.
So that the questions are jumbled, the order is changed.
Yes, it may not match,
It
but
cannot be done by us. It has to be forensically done.
certainly it will be done, Manoj, by today itself. It would be sent. I can make a statement. My lord, my last submission, Lord, I respectfully rely upon your lord, my lord, the Chief Justice's judgment in 2021, Volume 4, SCC 631. I'll not read.
2021.
Volume 4, SCC 631. This was also use of unfair means. My lords were pleased to, my lord, consider the case law on the subject and, my lord, observe at page para 56. And I would rely upon respectfully on the last part, but I'll read that para. The decision in railway recruitment, etc., all go to emphasize that a recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process stand vitiated, as a result of which a fresh selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, substituting its own subjective opinion on the sufficiency of the material which has been taken into account by the decision-making authority. Undoubtedly, fairness to candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the tainted from the untainted candidates. Now, please note this, my lords were pleased to say this. On the other hand, there may be situations where the nature of the irregularities may be manifold and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the tainted from the untainted. A considered decision of the authority based on the material before it, taken bona fide, should not lightly be interfered in the exercise of powers of judicial review unless it stands vitiated on the grounds of unreasonableness or proportionality. And, my lord, the decision-making process, my lord, I have shown to your lordships, it matches pan-India. There is no spurge. It matches earlier year and the year before that. And even the investigation suggests a localized, identifiable irregularities, my lord. And therefore, your lordships may not, my lord, exercise the judicial review. That's the respectful submission. Last, my lord. Lord, last, the question, my lord, that wrong and right question. My lord, I have also received several mails from unknown people, and I don't wish to rely upon it, but the common thing, my lord, common thread which is coming is that there are old books which are available. The old books contain a wrong answer, but in the of NCERT book.
But your instructions say that students must go by the latest edition, right?
No, my lord, the instruction says that, give me that in case of dispute, both the marks to be counted. Guidelines, my lord. Give me the guidelines, sir. Yes, my lord. My lord, page 70 of my affidavit in Vanshika Yadav.
Yeah, there's one correct answer here. How can we have, and you know, the thing is, option 2 and option 4, there may be a situation where the question is ambiguous and possibly both may be correct answers, logically speaking, in a given case, that you have 4 options. Option 2 may possibly be a correct answer. Option 4 may also is really the correct answer, but option 2 is also so ambiguously framed that it may also be correct. In a given example, here, if you look at the answers, each of them excludes the other. Each of them excludes the other.
Let's see. I'm just making an attempt.
Let's just see that. IIT director ka de do.
My lord, if your lordship sees the question, my lord, for a second, it's a trick question, my lord. I won't say, my lord, it's a ambiguous question. It's a trick question.
Yes.
Statement 1, we can, I may not read. 2, again, I may not read.
Yes.
Now, see the question. In light of the above statements, choose the most appropriate answer from the options given below. No, not the correct answer. Which is the most appropriate? There, my lord, possibility of 2 and 4 both being correct.
But see, option 2 is both statement 1 and statement 2 are correct. 4 says statement 1 is correct, but statement 2 is incorrect. So both can't coexist together.
I understand. My lord, one rules out the other.
Yes,
I'm my lord, I cannot defend, my lord, something which is not, but, my lord, kindly appreciate, my lord, the wrong answer published by NCERT book since years.
Now, just for factual clarity, the wrong answer is option 2. We are taking it as option 2, though in our order.
It may be.
We will just mention the question because you know the question number, etc. may be jumbled.
Jumbled, yes.
So I'm not sure the options are jumbled also. Options may not be jumbled, right?
The options are also jumbled.
Right. So we will just so that there is no
better to quote the.
We'll just quote the question. Now tell us one thing. What the option 2 appeared as an answer in which NCERT edition?
Yeah, yes, my lord. My lord, that appeared.
Your Lordship, prior to 2019. In 2019, the edition has been changed.
No, my lord, that appears to be not a very correct information. My lord, my information is up to 21, it continued. But subject to, my lord,
Your Lordship.
my lord, if some student can come, my lord, the old question, old wrong answer, till what time it continued in NCERT book? Till 22.
Edition came in November.
Yes, well, the revised edition came in November 22. But one of the students wrote me a mail that before that we have already started preparing.
Your
Revised
Lordship,
edition came in.
what Mr. Tushar Mehta is saying, what my case is, I started preparing in 9th grade itself from 2020 onwards. So I bought all these books in 2020 itself. I have a copy of edition in my petition I have annexed that 2019 had the same statement which was revised in 2019 October, and thereafter in 2023 as well. The same statement.
Want to trade like a pro? Do it on Grow. Check out Grow Terminal, where you can do everything on one
answer. Now, suppose let's take an extreme case. Let's take a case where the latest NCERT edition gives a wrong answer, but a student who has prepared well gives you a correct answer. Will we give that student?
I get, Manoj, what your lordships are calling from your lordship. But, Manoj.
IIT tells us what is the correct answer.
No,
There be
but-
no-
Lordship, the IITs
but
have
only a minute.
correct knowledge on the subject matter, your Lordship.
Only a minute,
Yes,
ma'am.
yes, ma'am.
Look, at the
And
same
yesterday,
time,
look, yesterday we referred it to IIT with your with your consent ultimately.
no, I consented, Manoj, not.
Let's
But
go by the IITs. They are
the
the
respectful submission is this, Manoj, and I leave it at that those who relied upon an authorized text of NCERT and Manoj, given the option accordingly, Manoj, should also not get the Manoj, disadvantage of that.
No, Mr. Mehta, the question here is not about the correct question, rote learning. You have to have the fundamentals clear. So far as an unstable atom is concerned, it has to be a radioactive element. Then it becomes unstable. Otherwise, protons, neutrons, and
Manoj, I am
electrons are
not joining
so
issue.
So being a science student, I'm a little bit aware of it.
The matter
The
ends,
answer
Manoj,
is so
ends
clear.
there.
If anybody has his fundamentals clear, he will answer it. So if he is bound only reading textbooks which are incorrect, he will render incorrect answer.
and though we gave the director time until 12, before 10 o'clock we had it on our table
He
report.
would
because
not
they
have
must
taken more than
the
2
experts
minutes,
Must have taken probably 10 seconds to answer the question.
But Manoj, the persons who will be affected would be around 4,22,000.
Your Lordship, but that also has to be considered how many of them are within 1,08,000, your Lordship.
No, everyone would be. They may come, they may go out. We do not know how will.
Your Lordship, the inflation itself is the big bug in this entire examination, your Lordship, due to only this question marking. No, 290. 256 or something.
This report, I tell you.
Was given by 9,28,379 students. So the larger proportion were all giving the correct answer. Option 2 was given by 4,20,000.
Your Lordship, the challenge was made by less than 0.6% of students who
Manoj,
challenged this question.
basically, Manoj, Manoj, without going into which answer is correct, Manoj, treating 4 to be correct.
15 questions.
The
Which,
only one last request, only one last. Question number 4 is the correct answer.
So just wait till for you to wrap up for a minute. We'll not close your argument right now. Let's just hear,
Yes.
because that's the perspective of students. That others are, who lose to lose, who stand
Your
to lose
Lordship.
by mark. So let's see what.
Please.
Mr. Solicitor, don't just keep your thought with you so
Yes,
that we'll hear you up.
if I may circulate a note. The main argument here is this applicant, she is AIR 1. She is scoring 720 out of 720. While attempting this question, she was faced with two situations. There's a tabular chart, Manoj, on the second page.
Repeat that you are.
If she
You are-
would not have attempted the
She
question,
is ranked number 1.
rank number 1, 720 out of
720 out of 720.
Yes. If she would not have attempted the question, it would have been -4 for her. So she would have ended up scoring 716. If current situation is executed, now if the current choice is treated as incorrect, that will be -5 for her. So this will be 715. So now she is in a peculiar situation where she will end up getting even lesser. If she would not have attempted the question, she would have been at 715. Because the second difficulty is that in the information bulletin, there's no whisper at all of the fact that there's some new NCERT book which is to be referred. And the old NCERT book is very well on the website also. Because we have made an argument that the rules of the game cannot be changed in between. If Manoj may see one judgment, 2011-10 SCC 51, it's the rules of the game, if I may just read the relevant part.
Instruction that if there is a dispute regarding the answer, then the answer given in the NCERT will be treated as correct. Is there any instruction of that nature?
Manoj, as per...
So is there any such instruction?
No.
So the
one very important thing in the FAQs which they release post declaration, what do they say? This was also done as a policy mentioned in the information bulletin of the NEET-UG 2024. That is, now see, this is very important. If more than one option is found to be correct, then 4 marks plus 4 will be awarded to only those who have marked any of the correct options. So this
Yes.
applies in a situation, Tanvi, where 2 answers are found to be correct.
Yes.
If 2 options are found to be correct, then if you adopt any one of them, you'll get +4. This is not a case where option 2 is correct. Only option 4 is correct.
Well, we are saying that as per option, there are 2 options which are jumbled in each set. So if both statement 1 and 2 are correct, and the today's version of the answer, as per this expert opinion, either or will be treated as correct if there's an ambiguity. Well, our respectful submission is that if in case of this ambiguity, if now
I
plus...
thought you were saying that she will make it to AIMS Delhi.
Yes, Manoj.
She will not go to AIMS Delhi, but someone,
And
you take it from us that, we are as sympathetic as anybody else because we realize that. But also there's not a situation where there's an element of ambiguity also, you see. There's not even an element of ambiguity.
may I just make a ambiguity is in the information bulletin. And in fact, this book is still now it's on the website. The ambiguity lies there that if there were instructions and this applicant...
That's still on the website, is it?
My lord, even civil services examinations, the students rely on NCERT. It is considered to be standard. My lord, Justice Misra is
Lord,
right.
my
There is no instruction
Argument
that
on
you can
principle.
argue, you can read only NCERT.
Right,
My lord,
yeah,
may-
Share for a minute and then we'll go back to the solicitor to wrap up.
Yes, my lord, just the argument on principle. Let's assume that we don't want anyone to be disadvantaged. My lords, we want to consider what might be an overall solution over here. My lords, we're testing a competitive exam. We want to test everyone on the same basis. The version of keeping this the same, the best way would be to remove this question at all. Because then what happens is that in a competitive exam,
You didn't
Lord,
answer it.
Your Lordship,
absolutely undertake.
Your Lordship, the candidates who have answered it wrongly will be benefited of that negative marking, Your Lordship.
No, they
Also-
won't get the negative marking. That's the advantage. Anyone, the negative marking won't affect them then. That's the advantage. No, it's, the question is removed. Just one last.
Just, Mr. Solicitor, talk to your directors here, right?
Yes.
You can ask him, we'd like your assistance on this. What if we do this? See, with the IIT report now, it's staring us in the face. Now, can we in our order, assuming we are not setting aside the whole exam, if we are setting aside the whole exam, all this is irrelevant. You know, then of course the whole exam goes. But assuming that they are wrong and assuming you're right on the whole exam, we will take a call on shortly. What if we say that, look, only option number 4 will be the correct option, but for anybody who answered option 2, there'll be no negative mark.
That appears to be.
What do you think? Just talk to Dr. Kamakoti and the director.
No, he is the director,
IIT.
IIT, my lord. Your lordship wants me to
But just have or talk to the director, NT only.
NTA.
In this regard, can I make a submission, Lords?
This one.
If
I will hear you.
Yes.
I am for a petitioner wherein one student has scored 720.
4 is correct. Then obviously.
720 and he's selected option 2.
2.
You have selected.
Not get
Option
negative.
Like Tanvi.
Like, so my lords, what I am informed that they have purchased the books in June
4
22.
also. But he will
Till
not get
till
negative
June
mark.
22, the same book was there, which was having the option 2 as the correct answer.
That's why what we are suggesting is that we will not give an additional negative mark.
But 4
If
marks.
we-
I think, my lord, it's reasonable, my lord, with profound respect, my lord. But it may, lordship may ensure that it does not become a precedent. Otherwise, for every question, there can be a litigation. And I am appearing in some of the matters, my lord, where, no, not in this exam, their questions and answers are disputed.
Each mark.
If there is this exam is for elimination and bringing out the best student for the best profession in the country, Your Lordship.
That's what I think. There will not be harm.
Anything
Injustice.
more? Anything more? Or you now?
No, only one, my lord. There was a my lord, faint but attempt to allege bias. IIT Director Madras. We have filed an affidavit that he has never attended any of the meeting. He is member of the general body of NTA.
IIT Madras is a member of the general body of the
General body which takes a policy call.
not coordinating the exam this year.
No, it has nothing to do. But in any case, he asked somebody else to come. We have a composition where whichever,
You said Gopal Krishnan had come. no?
yes, we have filed an affidavit to that effect. Kindly take that on record. And what we do is, as per composition, whichever IIT has organized JEE exam last year is our member to gain their experience. So last year was IIT Madras, therefore he is.
They came into this.
Therefore he came in.
Oh,
Our affidavit, my lord, is.
You are in the
He
same.
attended only one meeting, I'm sorry, I stand corrected, in December 22. But general body meeting for overall, my lord, accounts, etc., not for conducting examination.
Yeah.
My lordship.
But I'm appearing for a petitioner. There are 56 petitioners from Gujarat. All are right students. So what I've tried to do is I've shared one written submission yesterday.
So you have all got, how many have got 720 out of that? You
721.
don't want a retest, you want a retest?
We don't want a retest.
You don't want a retest.
Most of the petitioners have been selected, Lord. They have scored more than 650. And I'm also appearing for 6 intervention applications wherein 50 applicants are there.
That's
Out of
okay.
those,
Then they've heard that now the solicitor has argued for your line of.
there's only one point, Lords. Lords, we are, because everything, the data and the facts are before my Lords. The only thing is that we have tried to make a written submission where we have tried to establish the background of all those candidates.
That's all right.
10th, 12th and everything, because they
You're
are
not saying.
consistent.
Fair enough.
It's not only NEET.
You can't go into individual backgrounds because you know
That's what I'm trying to say is that not only NEET they have performed well, but there is an exam of good set. Even in those exams, they have topped.
Fair enough. Yes, Mr.
My-
Villa.
Please,
Sure.
Lordship.
My lordship, if I may.
Yes, ma'am.
On a
Yes. Sir, I have a very limited purpose, sir. I seek to represent students belonging to tribal, rural, and basically remote areas and EWS categories from Madhya Pradesh. They are being represented by a socially minded teacher. She's a medical professor, sir. Sir, the issue here is that we face is that these students, some of them come from very remote areas, some are even Naxal regions. For them to access an exam center or even sit for a test once is a very expensive exercise, leave alone doing it again. Some of them have even qualified and they have been seeking assistance from professors and guidance during the ongoing litigation. All we request is that if a retest is ordered, these students may kindly be either exempted or some sort of exception may be made for the process to be eased for them, sir, where their prior scores may stand in case.
Ma'am, if we order a retest, we can't create an exception. Then logically we will be incorrect.
My lords,
Either we do it, we have to use the same yardstick for everybody. The fact that there may be students like your candidates coming from tribal areas, poor students will have to go through the entire process, may be a ground not to order a retest. But if you order a retest, then we can't start creating exceptions. Then there'll be our judgment will be very vulnerable. We then have to apply one cut across then.
my lords, in that case, I seek my lord's permission to assist my lords
You
with
may,
the
therefore,
judgment.
your first point that we take it as a point that, ordering a retest
Sir,
will substantially prejudice students, especially students coming from the poorer backgrounds, marginalized backgrounds,
Sir.
like your class. That point we took.
sir, with your permission, if I may put forth my lord's observation in Sachin Kumar versus DSSB, which learned solicitor sir presented. So basically, by your lordship's principle, these students are obviously not beneficiaries of any paper leaks. And if they are put on the same yardstick as the wrongdoers, then it will be a violation of Article 14. That is my lordship's observation in the matter.
Point the solicitor.
And such an exception has been made by the judicature of Patna in Bihar STET leak few
Create
years
an exception only because, because then you belong to, say, tribal students. There may be Dalit students. There may be OBC students who also come from a very underprivileged background. Then where do we draw the line? There may be disabled students. Drawing a line becomes very difficult for the court, becomes a little arbitrary. So
I would seek your
but
consideration.
We've seen your first point. We'll
My lords.
take it.
Obliged.
Thank you. What's your name, ma'am?
Tanushri Bhalla. Obliged.
With Your Honor's permission, may I just make a submission? Your Honor, I will take less than 10 seconds. I'm appearing in IA number 140274 of 2024 in the lead matter. My Lord, I adopt the submissions which have been made by other contestants. I am also appearing for an applicant who has secured 658 and he is opposing the conduct of re-NEET. He opposes scrapping of the exam. The important thing why I'm addressing the Honorable Court is, my Lord, that there have been instances where unsuccessful candidates have approached high courts, sought orders against the NTE, and the high courts have judicially determined that such prayers are being made on the basis of forged and fabricated documents. And in my IA, my Lord, I have appended the order passed by the Honorable Allahabad High Court on 18th of June. When a petitioner approached the High Court, he sought scrapping and all those reliefs, stay of counseling. The NTA appeared, produced original documents of the candidate. And it was eventually then the petitioner's counsel sought to withdraw the petition. And the High Court was kind enough not to penalize the student for filing fabricated documents. So, my Lord, the only submission is that this entire exercise, bona fide students are suffering. And some.
What's your point?
Thank you.
Lord,
Yes, Mr. Wood.
basic principle which has been laid down by this honorable court is, if there is a leak, Lord, in this case, leak is admitted. If after the leak,
Be excused for 10 minutes.
Yes.
Lord, after the leak has happened, and the leak was done by the gang head, Lord, who has not been arrested, Sanjeev Mukhia. What is there in public domain, the CBI has not brought it on record. This Sanjeev Mukhia, who is yet to be arrested, is involved at least in 5 major paper leak cases in UP, Haryana, Rajasthan. Well, these are the news items. It is to be verified by them. He's not been arrested. The moment, Lord, it is established that leak has happened, dissemination is through WhatsApp mode. The handiwork of a gang operating in different states. Now, Government of India taking a firm stand that the leak is now, the beneficiaries of the leak are confined only in Hazaribagh and Patna. And this confidence emanates from only and only one fact, that the accused in custody so far have said that the leak is confined to Patna and Hazaribagh. Patna police, when records 161 statement of the accused, they talk of leak prior to the date of examination. This is also 161. Subsequent 161 statement recorded by CBI probably indicates that the leak is on that date of the examination. Now, my Lord, when the CBI officer was talking to this honorable court, his expression, as I could gather, was that so far we have not been able to recover the mobile phones through which this dissemination happened. So we cannot say with confidence that this dissemination happened only in Patna and Hazaribagh and not beyond that. So unless, my Lord, because after the leak has happened, the question paper is sold and there is sufficient time, even if the leak has happened on 5th. Then, my Lord, this honorable court ultimately, if sustains this examination, will have to record, in my view, a satisfaction on the basis of the material before this honorable court that we are able to segregate tainted from the untainted, and this satisfaction Lord, this Admittedly planning 2-3 months before by a gang. CBI officer specifically used very cautiously the word that so far we have not gone beyond Patna and Hazaribagh. CBI is not so novice that they will accept the statement of the accused arrested so far and close the investigation from the angle that whether it has gone beyond Patna and Hazaribagh. It is an evolving situation. The day we came first time before this honorable court for the writ petition, because mine was the first writ petition, we didn't know anything. Besides the fact that there were news items that there is a leak in Patna. Now, the main accused has not been arrested. Now, I would say the confidence with the learned Solicitor General to say that it is confined only and only to Hazaribagh and Patna is completely baseless. Investigation is going on. Can they file an affidavit that henceforth there would be no investigation to see whether it has gone beyond? If tomorrow, today the judgment come, tomorrow this Sanjeev Mukhia is arrested along with the mobile, which would show that he had sent it for 200 people in Sikar or different stations. I got to know that from Patna people have gone to Muxar, Punjab to give a paper. And if here they say 4 locations they have been able to find. Suppose there are 100 more locations involving only, say, 1,000 people involved into 20 centers. How many people would those figures, if all of them have got, all of them will not be topping, all of them will not get 720.
So would I just assist us on one aspect? If the court cancel the examination today on the hypothesis that investigation is not complete, the main conspirator is yet to be arrested,
That's right.
And there may be a possibility, we can't say likelihood,
Correct.
but a possibility that in some future point of time, maybe even a foreseeable future, the leak may not be only confined to these two
Correct.
cases.
That's right.
But should the court, in a situation like this where 23 lakh students have appeared, and we are dealing with the welfare of students across the country, and that's the worrisome part. We look at it this way, both ways. Let's put it 1 second. Let's put it both ways. We can't, today you are right, absolutely, that we can't say that the leak, we can't enter a judicial finding that the leak is confined only to Hazaribagh and Patna.
Correct.
For the reason that the investigation is ongoing.
That's right.
Even CBI can't tell us that. Today, as of now, it is confined to Hazaribagh and Patna. CBI's investigation in the next 15 days or 10 days might reveal a different, an evolving picture.
10 more locations.
So, we also, on the one hand, can't say that the leak is confined only to Hazaribagh and Patna. Equally, we can't today say with any degree of even prima facie authenticity or substance that the leak has gone beyond Hazaribagh and Patna in such a widespread or a systemic manner as to completely affect the sanctity of the entirety of the exam. That also we cannot say. Therefore, I asked to that's why we want your assistance. Can the court, or would the court be justified in a situation like the one present to say that not on the basis of material which we have today, but on the hypothesis that some material in the future may show that the leak had gone beyond Hazaribagh and Patna. Therefore, today we cancel the exam on the basis of a hypothesis.
May I answer, my lord?
May not happen in future.
May I answer?
No.
When I answer, when I speak,
No, Matthew,
when I wanted to speak, your lordship prevents me.
You please sit down.
No, I'm among the senior, among the lawyers here, I am the senior most.
Sorry, you're not an amicus. I have not appointed.
No, I'm appearing for 10, 16 students.
Right.
When I wanted to speak, the Honorable Chief Justice prevent me from speaking.
Mr. Matthew,
And I have an answer.
He is arguing. You will not interrupt him when he's arguing.
I'm not interrupting, but I have an answer to say. I have an answer to give.
You don't answer my question. He is answering the question.
Okay, then, it's a general question. It's a general
I'm not
question.
telling you he's on his
No,
left.
I'm not interested in the
He is on
engagement
his
with
left.
the Honorable Chief Justice, but I wanted to say.
You please sit down. I'll have to have you removed from the court. You please sit down. I'm warning you. I'll have to have you removed from
No,
the
your
court.
lordship doesn't
Mr. Udo,
respect me.
one second.
I on my own will leave.
Mr. Matthews, I'm telling you one very simple thing. Mr. Huda is engaged in a.
Your lordship have tried every best not to allow me to speak and put forward my
no
convention.
right to intervene.
I'm not intervening, I'm leaving.
Yes.
But one thing is said, I wanted to say, I wasn't allowed to speak.
Yes, Mr.
When I was speaking, your lordship was showing the other side.
Yes,
And I have only one word to say, only
Yes,
one word
Mr.
leaving,
Mr.
one word to
Matthews,
say.
Please call the security people, have him removed from the court, please.
I only want to answer.
You will not say anything. You will not speak to the gallery. You will listen to me. I'm in charge of my courtroom.
Listening.
You just keep quiet now. Yes, Mr. Huda. Yes, Mr. Huda. Yes, Mr. Huda.
I'm leaving.
Yes, Mr. Huda.
Unfair.
Yes, Mr. Huda.
Please.
This is not a judicial.
Mr. Matthews, I will now be constrained to issue something which is very unpleasant. Please keep quiet. Sit down here. You want to leave? It's your choice.
I'm leaving. I'm leaving.
You don't have to. You do not have to intervene. You don't have to tell me that you are leaving. Yes.
No, because I sought permission.
I
sought permission to speak.
Matthews, you will not interrupt Mr. Huda. I will hear you, but I'll hear you after Mr. Huda is done. I am in charge of procedure in this court, and I've seen this court. I've seen the judiciary for the last 24 years. I will not allow any lawyer to dictate the procedure of the court. I will give you a full hearing, but after Mr.
All right.
Yes.
I have been
Huda.
judiciary since 1979. Since 79.
May I, my lord,
This is contemptuous.
What you are talking about?
My response is, my lord, straight away.
I'm leaving.
Issue is no longer res integra.
Yes.
This has been answered in para 20 in Tanvi Sarwal's case.
Yes.
And the proposition is like this. The moment this honorable court finds that there is a paper leak and the fact has been established that it is a paper leak case. In that situation, unless and until the Honorable Court reaches a firm conclusion that we have been able to identify all the culprits and there is nobody left in the system who has from a back door is entering and becoming a doctor. Unless that satisfaction is recorded, this is my proposition for my Lord's consideration. The examination cannot be sustained. And here, my Lord, not only one fact.
In other words,
I'm just putting all things
in other
together,
words,
my Lord, in a circle. Let me put all things together in a circle.
Your argument is that unless the court comes to the conclusion today
Correct.
that all the 10